Hi, I'm Bronwyn Williams. You're back with the small print, and today our guest is Mark Oppenheimer, and we're going to be talking about free speech. But before we get started, Mark, do you want to just introduce yourself and tell us a bit about who you are, what you do, and what you're interested in?
Sure. So I'm an advocate at the Johannesburg Bar. I specialize in free speech and hate speech litigation. And I also run a philosophy discussion channel called Brain Navat. So we sort of see that as a way of testing out open discourse. We have people who raise a whole range of weird and wonderful ideas, some of which are quite controversial, and we give them the space to express those ideas, partly to try and understand what their position is, and then to put challenging questions to them.
Okay, so what are some of the things you're working on at the moment in that regard? What are you testing in the courts at the moment?
Yes, well, the case that I worked on that probably set the framework for all hate speech cases is the matter of Jon Qwelane and the Human Rights Commission. So that case ran for a number of years. There was an initial trial in which Qwelane was held liable for hate speech. He then took the matter on appeal, where I appeared for him, and he challenged the constitutionality of the hate speech legislation, being the Equality Act, and was successful in that challenge. And that was then somewhat confirmed by the Constitutional Court, who found that the legislation was overly broad in that it sanctioned hurtful speech. So there'd been quite a lot of discussion in our various cases about what hate speech really is. And you had these different views. So many of your viewers will be aware of the Penny Sparrow case. There, the standard that was used to hold Sparrow liable was, is the speech hurtful? Does it target a protected group? And that was sufficient. So hurtful speech was hate speech. What Qwelane does is find that you must have a group that's targeted, either incitement of harm against that group, or that the words themselves are harmful, which is at a higher threshold than merely hurtful speech. Um, so that sort of sets the framework, and it's been used in all the cases since then. The most recent litigation would be the Kill the Boer case. So I ran that trial on behalf of Afriforum against EFF and Julius Malema for singing Kill the Boer, Shoot to Kill. And that went on appeal, and a judgment was just handed down. What we find in those cases is that different tests appear to have been applied. So, for example, the High Court found that you must have a causal link between the speech and actual harm, something that the Constitutional Court in Qwelane had found was not a requirement. The Supreme Court of Appeal reiterated the Constitutional Court position, which is that you don't need a causal link. So, calling for harm against the group is sufficient. You don't need to see the harm actually result. But they nonetheless found the speech to be protected speech, partly on the basis that they understood it to be political speech. They surprisingly also cite a judgment from the Constitutional Court that says you should have heightened scrutiny when dealing with politicians and those who are in leadership positions. But the SCA appears not to have actually used that heightened scrutiny. In fact, it has lowered the scrutiny.
In what way do you say that?
Well, if we think about a lot of the history of these hate speech cases, what you find is lone individuals who are kind of nobodies, like Penny Sparrow, are held to these very strict standards, raked over the coals, publicly humiliated in the press, made to pay big fines. Some of them are sentenced to prison. If you think about Vicki Momberg, sentenced to prison under different legislation, under Act 2 Nyoyarum, as opposed to it's under the law of crimen injury as opposed to the Equality Act. But it seems to be the case that political leaders are held to a lower threshold. That the allegation is that the songs like Dibulu Bunu or Kill the Boer shouldn't be given their ordinary meaning, that effort should be made to try and reinterpret them in a way that's not pernicious. So what the High Court does is to say, well, actually, Kill the Boer is targeted at the ANC government, the incumbent government, which seems like an interesting reading to make. And you find this, the appeal court saying, well, you shouldn't take literally the hand signs on stage with the shooting of guns, mimed, or that the words kill mean kill. They're really a kind of rebellion against the powers that be. And there was even moves to try and say that it's not possible to understand what the term Boer means. But the Supreme Court at least seems to acknowledge that Boer refers to Afrikaners.
But isn't that a sort of conflation of two different ideas? If you're taking the Penny Sparrow case in this case, I mean, the one was a personal case. It was a case of one person supposedly harming another person, an individual, in an individual context, and this is very much more in the political realm. And is there any sort of, should we say, precedent in terms of distinguishing between those two, which is a material difference? I think that most citizens would also agree there's a difference between the personal and the political. But of course, do we even have legislation that covers the difference when it comes to things like hate speech and harm through words?
Yeah, let me give you an idea of what the sort of framework looks like. So, as I mentioned, there's the Equality Act, which is how hate speech cases have been adjudicated. It's described as sui generis legislation, so it's its own type. It's not quite criminal and not quite civil, and has a range of different penalties in it that could be making an apology or paying a fine, things like that. Sparrow's case isn't actually aimed at an individual. So if you recall, it was a while ago, 2016, she'd put up a post on Facebook and complaints were then raised against her. Vicki Momberg's was personal in that she has a confrontation with the police officers and uses various racial epithets. She's dual prosecuted. So Momberg's held liable for hate speech and then also crimen injuria, and is actually sentenced to prison and serves time under the crimen injuriam. Interestingly enough, it's Roman Dutch law. There'd been findings in the 80s about using those terms of abuse, but people weren't jailed for it. So when you're looking at hate speech generally, it's the idea that it's not merely interpersonal. It's not that you've said something to an individual. The idea is that it's targeting a group. So one of the requirements for it to amount to actual hate speech is that you're not just saying we should go and lynch Bronwyn. We're saying we should go and lynch all members of Bronwyn's group. So we have a range of different groups that are protected. So race, gender, ethnicity, and religion are the ones mentioned in the Constitution, but that's expanded by the equality legislation, which includes sexual orientation, albinism, other ranges of things. So there's room to expand the grounds, but it's not merely personal.
Okay, so coming back to the whole EFF case, is this also just a bit of a being more enhanced in the media just due to the fact that we have elections on at the moment and all the rest of it? Why is now the case that is being tried? Because this is a very old song, as I'm sure the plaintiffs will point to. It's gone on for a very long time, but why is it making its way into the courts for actual decision making at this point in time?
Yeah, so you must recognize that litigation takes quite a long time. It's an old song, but not a very old song. So you rarely see it sung by Peter Makaba in the early 90s. There is a ruling by the Human Rights Commission itself in 2003, where they declared the song hate speech, the Kill the Boer version. In 2011, Julius Malema sang Dibulu Bunu, and that was declared hate speech as well. It then was, and remember that Julius was a member of the ANC at the time. The ANC largely abandoned the song and agreed that it didn't really hold a place in modern South Africa. Julius then starts the EFF and sings a modified version of the song where he says "kiss the Boer," but he says "shoot to kill." This then comes to a kind of crescendo in around, I think it's around 2019, when a young farmer called Brendan Horner was very brutally murdered and his body was put on display. And those accused of the crime were then tried in a town called Senekal. And at that town, you had members of the EFF engaging in a kind of counter-protest where they then sang quite clearly, "Kill the Boer." And so that's where the proceedings came from. So there isn't a kind of election around the corner, really. You have this idea that people are being killed, and the speech is dangerous and had already been found so by the Equality Court in 2011. The trial then goes on in 2021, and Mr. Malema testifies during the course of that trial, and he says a number of things that should be quite alarming. One of which is that he, when asked to pledge whether he would refrain from ever calling for the slaughter of white people, he refuses. He says that revolution requires killing, that when the time is right, he will bomb the Union buildings. He says that white should be driven into the ocean. So you have a lot of context for what that song is about. And a judgment then is handed down about a year later. So litigation takes its time. Then there's the appeal process. The appeal is then argued, and that appeal judgment has been delivered a couple of days ago. So the day before the election. So that gives you a sense of how it came about. I've spoken a bit about hate speech, and I haven't really spoken about the importance of free speech. So I really do think free speech matters, and our Constitution takes free speech quite seriously. So Section 16 of the Constitution grants these very broad free speech rights, and it includes academic freedom, freedom of the press, artistic creativity, which is not the works of art only, but also the creative process, and then has these limitations on speech, so they don't form part of the right. So the first is propaganda for war, the second being the incitement of imminent violence, and the third being the hate speech clause, which is advocacy of hatred on one of four grounds: race, gender, ethnicity, and religion, and that constitutes an incitement to cause harm. Now, the Constitution just tells you these are the things that aren't part of the right, but then it's up to the legislature to create legislation which actually regulates it. And as I say, that's been the Equality Act up until now. The Hate Speech Act has just been passed into law, and it tends to mirror the language of the Equality Act as modified by the Constitutional Court in Qwelane, but also creates criminal sanctions. So acts of hate speech could lead to imprisonment of 5 years. One should also bear in mind that hate speech is expanded in the old flag case. So there the courts find that displays of the old South African flag under the right circumstances could constitute hate speech. And so other sort of symbols could count as hate speech under the new act, and people could be imprisoned for displaying those symbols.
Okay, so that's a good point to draw from around the difference between hate speech and freedom of speech, because hate speech, as you just mentioned, is only sort of one category of unfree speech at the moment. But I suppose why it's an interesting one to talk about is that it is so interpretive, that it does rely on the courts to often determine what does constitute hate speech and what doesn't. And certainly looking at the sort of judgments, and you just mentioned a couple of examples today, it seems to be the court kind of rules whether something is hate speech or not as to whether it is tolerated by the people or not in general, by the popular consensus. This is something that I've kind of looked at in a lot of our constitutional court judgments. They seem to be very arbitrarily determined, number one, very arbitrarily applied, number two. But usually what is both determined and applied are judgments that reflect national peacekeeping interests, I would say, is probably the bluntest way to call it, as to the courts really just serving the function of upholding not necessarily justice, but certainly trying to uphold peace. I don't know if you'd agree with that, but from a sort of a completely outsider perspective, it's hard to find any other justification around why certain determinants are made and others are not.
Yeah, so there's different philosophical positions about how courts behave, right? So the one view is the natural law view, which is that courts think that there is a hidden set of rules that aren't necessarily legislation, and so they'll use that hidden set of rules to invalidate laws. The other one is called legal realism, which is the idea that judges have a particular outcome in mind, and that they'll find the rules to get to that outcome. And so an outcome they could have, as you say, is keeping the peace, or reflecting what they think the majority want. We know that the Constitutional Court has done many things over the years that are pretty different to what the majority would want. So, for example, if you polled South Africans about whether there should be a death penalty, a majority would be in favor of it. If you said, should we have gay marriage, a majority would be against it. So the Constitutional Court was unanimous in outlawing the death penalty and in finding that there's a constitutional right to gay marriage. You might also think that they made an unpopular decision for keeping the peace, in terms of saying that Jacob Zuma cannot stand as a member of parliament, which means he couldn't hold a cabinet position. One might think that the Electoral Court had made a peacekeeping decision there, and that the Constitutional Court applied the law as it sought. So I agree, one must always read judgments with this other motive in mind. And it's important that courts do their job, which is to interpret the law. And they are not meant to write the law. That's the legislature's job. And there may be constraints on them. One of the other cases that I was involved in was on whether our elections in 2021 should be postponed because of COVID. And there the Constitutional Court decided that there is no wiggle room at all. Our Constitution says that you must have elections every 5 years and that you're allowed a 3-month delay and no more. And so the court said, the elections must occur. And you had enormous amounts of pressure from the IEC to say, don't run the elections. So there is a sense in which our courts also have to publicly reason. You're writing a written judgment. You can check to see whether they have done what they say they're doing, and you can see if they haven't.
Yeah, but yet it still seems very interpretive. Like, is the court actually a separate pillar of our democracy, or is it really just a sort of bellwether that blows according to the wind? I just have been reading quite a lot of case judgments lately, and it does seem very arbitrary. Like, what are the real guardrails that the Constitutional Court places on democracy, other than in theory? Because again, it's applied so arbitrarily, and you've given us examples. We have a guy who, even in the first 2-3 examples you've given us, you can see how arbitrary the court is, and how, according to no sort of sense of actual laws, rules, or regulations, do those judgments make comparative sense, right? They are arbitrary, and I think it'd be very hard to argue otherwise.
Yeah, so there's definitely a danger when you're dealing with politicized matters or matters where people have a strong feeling that courts start to play around with the rules that they use. And I do think that is a concern people ought to have. I mean, one way to look at the golden thread in the hate speech cases, and there aren't that many of them actually, it's the kind of thing that gets a lot of press coverage, but I think there's maybe 30 quality court cases. I remember at one point, if you go to a high court, you'll see cases are numbered, 107,325 for the year. I was involved in equality court cases 1, 2, and 3. So that shows you the volume. It's tiny. But one way to look at the golden thread is really to say who's speaking and who is the group that's being targeted. And it seems that certain groups are protected. So if you're gay, for example, the Qwelane judgment protects you. If you're Chinese, there's a judgment that protects the Chinese community. If you're white, there's an argument that you're protected by Judge Sutherland in the Kamalo case. There, Valapi Kamalo, a member of the ANC, in response to Penny Sparrow, had said, we should do to white people what Hitler did to the Jews. They should be burnt alive, hacked to death, and their children turned into garden fertilizer. But it's quite rare to see things go in that direction. Sutherland specifically says that our law embraces the value of non-racialism, that we don't have different rules for different races, that everyone is equal before the law, and that your particular power status is irrelevant. So one would hope that that principle carries through, but as you've mentioned, there do seem to be some inconsistencies or some bendings, and populists should be, aware of that. There is a sense in which you should see the court as an independent institution, but one that's constrained. So judges are appointed to the Judicial Services Commission. One of the people who sits on the JSC is Julius Malema. I think he's one of the longest serving members for 10 years. He has publicly bragged about stopping certain judges from getting elevated. So David Unterhalter, for example, had tried on a number of occasions to become a judge of the Constitutional Court and the Supreme Court of Appeal. And he was basically vetoed by Julius, as has come out in minutes from those meetings. But Judge Unterhalter persevered and has now been put forward to the Supreme Court of Appeal. So there are political factors, and I think judges, are still human beings, and so there's a sense in which they might decide for non-legal reasons, and it's worth pointing that out.
But yet, from a citizen's perspective, I mean, as flawed as the current iterations of democracy are, we get to vote our politicians out. So we don't get to vote or have any say on the judiciary. And yet there's no challenge to the Constitutional Court. Once a judgment is passed, whether it seems arbitrary or seems in direct contest or contrast to previous judgments, we just have to accept it, right? Like, are there any checks and balances against the judiciary at this point in time? And at the same time, because that's one side of the argument, the other argument is that in terms of like the applications of their judgments, if you look at politics history, they're not always applied either. So on the one hand, there's the argument that that judiciary is kind of a toothless tiger, that its judgments are upheld when it's politically expedient to do so, and it's a great way to test where public sentiment is at before politicians decide whether or not to obey or disobey. But at the same time, when the courts are not necessarily acting in the same interest as you mentioned, the majority or the democracy, where does one go from there, right? Do we have to rely on the will of our politicians to obey or disobey, right? Which is a whole different story too, which brings us back kind of full circle to saying, what is the actual role this is fulfilling in our society? Other than, from my perspective, certainly, is it's a way to further the story, to continue the conversation, and to get topics into the public discourse that could then influence elections, which is a very roundabout way of doing things. I mean, there could be arguments to be said that the media could do that anyway.
Yeah, so one way of seeing the courts is that it has a limited amount of power, right? They have no purse and no sword, right? So there's no army that can enforce the court's judgments if people don't want to abide. What's interesting is that there are increasing amounts of disobedience. So what we're finding is that state officials ignore court orders, but that there are further mechanisms, which is you bring a contempt of court judgment. And at some point, if you keep ignoring it, the sheriff will arrest you. And at the moment, we don't have full disobedience. We have a kind of Stalingrad strategy with state officials kind of trying to slow down the process or avoid culpability, but we haven't had an outright disregard. So if you think about the Constitutional Court convicting Jacob Zuma for contempt of court, there was a standoff. There was a question as to whether he would hand himself over to the police, and ultimately he did. And he spent about a minute and a half in a jail cell before then going to a hospital bed, because the poor guy's very, very ill, obviously. Had a miraculous recovery to run a very impressive election campaign. And of course, you had a pardon from Ramaphosa, which was broad in scope and just happened to include him. So, he never really had to go back to jail. So you do have you have a dialogue of sorts. So the courts make a decision. The other arms of the state can react to it. You can have sometimes it takes a long time to get to a certain result. So a good example is, you heard of the Scopes monkey trial. There's a film called Inherit the Wind, which documents the trial. And basically what you had was a rule in, I think it's in Alabama or Mississippi, that it was an offense to teach evolution at school. And the thought was, we should test this. And that seems like an infringement on people's free speech rights. And so a teacher taught it and then confessed to doing so and then was prosecuted and was held liable. So the thought at the time was that the trial itself would be a piece of theater that could showcase what evolution was really about. Obviously, the theory that turns out to be true, but you had a lot of caricaturing of it. So it's called the Scopes monkey trial because people would say, you're saying I'm a descendant of a monkey and this is ridiculous. And it was then a surprise that he was held liable. And that law was only overturned, I think, in the 60s. And he was convicted in the 30s. So it took 30 years to change that rule. And so sometimes these fights are very long. And sometimes it takes a number of different court battles or changes in a public mood or changes from legislation. But you do find that courts can be a useful tool in, social progress and also social regress.
Yeah, changing the conversation, nudging the story is about the best one we can get there. But I suppose we have to look ahead, and coming back to the new evolution of the current hate bill legislation, which is not just a South African thing. There's these hate bills going out in each of the Five Eyes states at the moment, plus a couple of their close friends. And they all, again, open up the door to further completely arbitrary application, because quite a lot of them are framed not in terms of action, which at least our current bills are tried to be defined in terms of action. Did you say something to incite? Did you say something that crosses these particular protected group lines? We can debate whether those protected groups are deserving of special protections or not, but at least it's currently, there was an attempt to define the crime rather than to define the harm to the victim, whereas most of these bills that are coming out now shift the balance of conviction towards the harm caused to the victim rather than the crime committed itself. And when it comes, of course, to verbal crimes and verbal harm, of course, that's entirely arbitrary, and it's entirely in the eye of the lived experience of the supposed victim and the interpretation thereof of whoever gets to hear that case. Like, how can the law be applied even in a pretense of fairness when laws are defined so vaguely as to effectively be skeleton keys that could be applied against anyone or in favor of anyone according to just who we choose to listen to, really?
Yeah, so you're right. There's a danger in using ambiguous terms. If you think about the text used in the Constitution that I referred to earlier, so you have a term like war. We know what that means, right? It's a cataclysmic amount of violence.
Or
We're thinking about, bloodshed, destruction of property. Harm. We're saying, okay, some kind of lesser thing, but it must be serious and significant. Hurt being very low. So my emotional response. And what we found is that certain words are ambiguous, or that there's a political maneuver to try and describe them in that way. So people will say, silence is violence. So you're complicit if you don't speak out against this terrible thing and you've done something violent, or your presence is violent. So those things are said partly because there's language used in legislation, and so people are trying to fit this square peg into a round hole on purpose. So, yeah, there is a danger in that. The Hate Speech Act does define harm, but in very broad terms. So it talks about emotional harm, psychological harm, financial harm. So there's a sense in which calling for a boycott, for example, against a particular group might land you up in jail. I've been involved in quite a lot of lobbying efforts around it. I think it probably is too broad. I think it will be used to silence people. And one of the people who might very well be sent off to jail, depending on how our politics look, would be Jon Qwelane for setting alight the new South African flag. You can imagine that being the kind of tool that you could use, and if you drew the right magistrate or judge, you could get an outcome like that. And that's obviously the kind of thing that should be chilling, knowing what the intent was with that DA ad, which was really to, fight against the forces of darkness, as opposed to, celebrate the destruction of the country. So there is that worry, as you say, that you've got the vague language. And what you want from a rule of law perspective is a lot of specificity. So what we find is that we've given a lot of discretion to courts. So we sort of say things like reasonable. Who's reasonable? It's not the kind of thing that we know objectively. One of the reasons why psychological harm might be different to emotional harm is that you might need an independent expert like a psychologist to assess whether you've had the harm. Are there expert reports that show that you've been going to therapy, that you are on medication because you've suffered this wound, as opposed to I'm angry or I'm sad, which might just be a matter of that individual reporting it.
Yeah, but I suppose even when it comes to physical harm, you can, of course, still interpret that as long as a piece of string. I mean, we all know the uses and abuses of things like the Road Accident Fund. I'm sure many of the people that might end up listening to this know someone who has perhaps taken advantage of such system, who might have taken some advice from a lawyer as to how to pass or fail a physical test in order to maximize your claim from such systems. So, like, these things are certainly not free from abuses. Not saying all of those claims were fraudulent, but they open themselves up to interpretation. But then you say you move away from psychological harm towards emotional harm. Like, please explain to me how the court is going to judge someone's emotional harm.
Yeah, so there's a concern there. I mean, to give you an idea, some of the evidence that was led, so to contrast the two cases, so Qwelane's case, you had evidence of, just to remind listeners, Qwelane had written an article in 2008 where he said, I pray that politicians would have the balls to change those parts of our constitution that allow a man to marry a man and ditto a woman. This was about 2 years after gay marriage was put in. So it was quite a live debate at the time. And obviously people were free to have that discussion, and did for quite a long time during the legislative process. So Qwelane, being a devout Catholic, had expressed this view. So the kinds of evidence that came out were people saying, well, you have corrective rape in townships against lesbian women, that words like this contribute towards that environment. There was no causal link ever shown, but the idea was that you've got this kind of social background harm. You had people talking about the trauma they'd suffered when they'd read those kinds of words. So in the Kill the Boer case, you had similar kinds of evidence from experts and from individuals. So, for example, There were testimony from people who'd survived farm attacks, who described what it was like to survive such an attack. The one woman had her husband executed in front of her while she was 9 months pregnant. The other one's wife was killed in front of him, and he was shot in the spine. And they both testified that when they hear Kill the Boer being sung, it brings back those memories and brings back that trauma. You then had a expert who consults with the communities that have suffered farm attacks and talked about, the trauma to the community, the amount of therapy that they go through, what's involved in the therapeutic process, and then the kind of large-scale impacts, how often these things happen, what's involved in them, the connections between real-world violence and the use of the phrase. So there was a mother and daughter who were brutally killed. The daughter's breast was cut off with a broken bottle, and it was unclear whether they'd been raped because their genitalia had been so badly mutilated, and then Kill the Boer was written in blood on the walls. So you get a sense of what actual trauma would look like. And it's interesting that in the Qwelane case, those facts are taken very seriously by all the courts, and ultimately Qwelane is held liable, even though the act is held to be unconstitutional, whereas the EFF were not held liable, despite similar kinds of evidence.
Okay, but that's still like in the realm of psychological harm. Like when we start defining it now around emotional, it just adds an extra degree of ambiguity to anything that comes out, right? And it almost becomes unfalsifiable on the one hand, and also unprovable on the other hand, depending on the case at hand. And doesn't this give courts too much power? Because as much as I've spoken about how in many cases, we all know courts don't have their own armies. They're effectively toothless tigers when it comes against the government, and only a government that wants to look good in the eyes of the population is going to uphold it. It's more of a self-preservation thing than a threat of any sort of consequence there. But at the same sort of time, when it comes to individuals as opposed to the government, individuals are absolutely at the mercy of the court. The court's decisions are absolute when it comes to you or I, even if they can be interpreted, ignored, denied, or sort of outright disobeyed when it comes to the government in practice, right? So, what is the risk to individuals when you go ahead into very vague, very ambiguous legal territory, like we are headed towards? And again, I'm saying this is definitely not just a South African thing. This conflation of the risk of harm with harm, the conflation of verbal harm with physical harm, and all becoming now a great global health and safety issue, opens up huge opportunities for use and abuse of power, even by entirely democratic and law-abiding governments. Now we're not talking about the governments that ignore the courts. We're talking about the governments that say, oh, but the court did convict you, and you are now convicted. And this is talking from both the perpetrator and the victim side of the future of law when it becomes so personal, really.
Yeah, I mean, you're right to point out this is not a South African only issue, and that if you look at a lot of speech codes in Europe, they tend to be very restrictive of speech, and that can be quite dangerous. It's dangerous partly because you have a chilling effect. So there might be protected speech that you could utter and would be part of your legally protected free speech rights, but you're too afraid to say it. One reason why it's important to have people being able to speak freely is that it's how we find out what's actually true. So when people say controversial things and you test them up against each other, you have this clashing of swords. So if you think, for example, about how speech was dealt with during the pandemic, there were certain things that were deemed unutterable. So those that questioned the efficacy of masks, for example, or those that thought there might have been a lab leak, that kind of speech was, often banned or quashed or made hard to get to access to. And in the fullness of time, it turns out that there might be something in those things, and it might have been useful to have had that conversation, in the presence of sunlight, so you can find out what's false and what's not. The other useful thing for having speech that you might find disreputable and distasteful and horrific is that it gives you an indication of the temperature in your society, and it also acts as a steam valve. So if you say to people you can't speak, you then remove the options for how they express themselves, and so they might resort to actual acts of violence, as opposed to being able to just let off steam online or in speeches. Of course, as I say, that there are some kinds of speech that generate real acts of violence, and that's the kind of speech where one should be concerned. Of course, we wind up in an absurd scenario where the really dangerous speech is protected, and the banal speech is suppressed. And so that's why an independent judiciary makes a big difference, and one of those things that must be jealously guarded and not to be taken for granted. I was at a News 24 conference a while ago, and the journalist said, the country's in a really terrible place, but at least we've got these two wonderful bastions, the free press and our wonderful court system. And I spoke to another journalist, and I said to him, what's your take on the press? He said, Mark, I'm actually pretty worried. I think that we've juniorized the newsrooms. A lot of the really brilliant, talented guys got pushed out because we couldn't afford them. That there are probably people who are taking bribes. There's probably people who are ideologically captured. And yeah, it's not a space we'd like.
Born at the same time, right? So, I mean,
Sure. He said to me, how are the courts? And I said, well, we've got some serious problems. It's an open secret among lawyers that, the judiciary doesn't look like what it used to. I think a lot of people could name who was in that original set of judges of the Constitutional Court, and would probably struggle to name more than 3 judges who sit now. That the Judicial Services Commission has, been in the spotlight a number of times for engaging in quite hostile conduct. A lot of very talented lawyers don't want to put their names forward to serve. So it's, the price of freedom is constant vigilance. We don't win it. You have to keep fighting for it.
Yeah, it's acting against that state of nature all the time. But the other thing I want to talk to you about was other people's gods, right? How's the state of blasphemy laws looking in South Africa? We've got blasphemy laws in Europe where people are getting convicted for insulting other people's imaginary friends. But how are we doing in that regard here? Because I haven't seen any cases myself, but I mean, you're definitely closer to it. And I think it's also linked towards the free speech conversations. You mentioned religion from the other side, where religion is getting in the way of freedom of association from the other side of the equation, where it's in the dock as opposed to being the plaintiff. But where are we sitting with that?
Well, you've probably watched The Life of Brian. And it's one of the great satires. And there's a scene where someone is being stoned to death for blasphemy. And the high priest, being Jon Qwelane, says, we are here on this very solemn occasion to sentence this man to death by stoning because he uttered the word Jehovah. And the crowd, who are mainly women dressed as men, so they can participate in the stoning, who are, of course, men dressed as women, dressed as men, start stoning the priest. They say, he said Jehovah, he said Jehovah, he said Jehovah, and they start stoning him. And then the old man sort of says, I don't understand why I'm here, because all I said to my wife was, this meal is fit for Jehovah. He said Jehovah, he said Jehovah, and they start stoning him. So there's a sense in which we've embraced blasphemy laws, not about gods, but about other things. That there are certain words that, regardless of context, are now seen as beyond the pale. There's some very amusing examples in America. There's a Netflix executive who said, I'm quite uncomfortable that we have comedians use a particular term. He says the term out loud, and he says, I'm not so sure we should be content. And he's then fired for it. Right? There's someone at the New York Times. There's I think the prior VC of Wits got into a similar situation, denouncing the word while using the word. We're now in a situation where neither of us will say it, because that's what the climate looks like, right? Neither of us wants to say Jehovah. So that is a strange case. In terms of our actual blasphemy laws, we don't have direct laws like that, but there's an argument to be made that the hate speech laws which protect religious groups could ultimately be read in such a manner that if you were to say something about a particular religious group's deity, that they would describe it as harmful speech that propagated hatred against them. We find different religious groups seem to have different views on this. So I think if you wanted to put up a rude cartoon of Jesus, I don't think anyone would really blink. But I don't think you'd even consider doing that for the Prophet Muhammad.
Yeah, what are the chances of those laws being applied, shall we say, uniformly, if such groups do take offence and start taking these cases to court? Or are there going to be some religions that are more equal than other religions? And I think in the South African context, that's a more interesting question. In Europe, we already know some religions are more equal than other religions in the eyes of the law, and that you can throw insults at certain people's gods, but not so much at other ones. Whereas in South Africa, the demographics and the inherent conservatism of our culture, which is something that you kind of mentioned, that actually the courts in many cases are more progressive than the people who fail to vote for them. I'm really curious as to your thoughts as to how this is likely to play out and who the actual protected groups are going to end up being. We already know who the protected groups are when it comes to sexual preference, when it comes to gender, when it comes to race. And many of those do have historical context, particularly in our country. I just think that the odds are perhaps more distributed around which groups are going to end up being the most equal of among equals when it comes to religious blasphemy questions going forward, because these new hate speech legislations are almost definitely going to open up that can of worms and see these things tested in court.
Yeah, I think it's a possibility. So those cartoons of the Prophet Muhammad were banned in South Africa briefly. There was a case brought to interdict the Mail and Guardian from publishing them. So that is a concern. I suppose one way of thinking about the law is that what you're doing is setting up a bunch of loaded weapons. And if you are in an environment where your judges will apply the law as they find it, and our law is drafted neutrally at the moment, it doesn't say that one group is superior to another, that people might be afraid about picking up that loaded gun lest it be used against them in retaliation. And so if you trust your bench and you think that you haven't got a particular group that's dominated it and there's no chance of you ever getting justice, then that can act as a temper on things. As you say, judges are human beings and they might very well apply what they think the majority of people want. Often judges can be out of step with that. I think it's quite hard to get yourself into the minds of your spouse or your friends. Imagine getting yourself into the minds of 60 million people who live in the country with you. I think people think they know what the pulse is, but they can often be highly mistaken.
Yeah, that's going to be an interesting one to play out. And are there any other cases that you've seen globally around hate speech laws? Because as I said, many of them have come into efficacy this year, actually, within the last sort of 3 months or so. I think you've got them in the UK, the US, Canada, I think even Japan's looking at it, and New Zealand, Australia. There's a whole bunch going on all at the same time. Are there any test cases that you've seen so far coming out of that? Or is this all theory and not too much practice yet? Because as you said, these could be quite dangerous toys. Live by this particular sword, you could very easily be cut by it too.
Yes, so I think you found a little bit of that in Scotland. So they produced a law that could really be quite devastating for free speech. And J.K. Rowling, made a point about this and said, well, I imagine that I'll get arrested as soon as I land back on Scotland shores. And then complaints were laid against the Prime Minister under the legislation. I mean, it's quite possible that a complaint will be laid against Ramaphosa for singing From the River to the Sea, which some interpret as a call for the annihilation of the Jewish state. And Ramaphosa having just signed the Hate Speech Act, a couple of days ago. So, yes, it does depend who the other role players are. I mean, I think you've got to see institutions as not fully autonomous. It depends on the other agents around them. You've got corrective services, you've got the NPA, you've got the populace, you've got civil society. So, all these things kind of can work in concert with each other or a competition with each other, or in an adversarial way. And so it is dangerous. I think one of the mistakes people make is they think our side will always win and our side will always be popular. So one of the arguments that I made during the old flag case was say, if you create a principle, which is that any symbol you deem to be offensive can be banned, well, one of the symbols that people find very offensive all around the world and you can get incarcerated for is the gay pride flag. And we think it would be a very bad thing if that flag were banned. And Josie Pride joined the litigation. And instead of seeing that there's this possibility of their flag being banned, they called for further reasons to ban the All South African flag on the grounds that it's a homophobic flag. Of course, if you took that argument very seriously, you could then look at the 77 countries around the world where it's illegal to be gay, many in Africa and the Middle East. So then you would want to ban those flags too. So, there's a short-mindedness. There's a sense in which some progressives think they'll always win. What's interesting, if you think about the free speech movement in America, it grows from the left. It's the Berkeley free speech movement. And now on American campuses, you have this strange view on free speech, which is basically free speech for me, but not for thee. So if we're chanting for the destruction of Israel, well, then we should be free to do it. If you're going to say something that could possibly be interpreted as racist, well, you definitely can't say it, and we should destroy you. So, there's a double standards problem and a equivocal approach to free speech from certain political sects.
Yeah, it's very dangerous when you banning people from naming things. When you can't name a thing, you can't fight a thing. You can't argue against it, right? You have to use pseudonyms, you have to use symbols instead to talk around it or to talk around that issue. And that's of course not healthy for any society at all. But again, when it comes to the sorts of things that are banned or are not banned, I think there's also sort of an argument to be made, not necessarily a legal argument and not a moral argument either, but an argument towards sanity, that as much as we can have these conversations both directly and obtusely, talking around the words and the things we're not allowed to talk about and the issues that we're not allowed to support, because we all kind of know what they are. At the same time, right? We all know what the current suite of politically acceptable stances to take and politically correct hypocrisies are to hold, right? There is a sort of cultural consensus around who's on the right side of history, even as that right side of history is constantly shifting, very often to the left, as you might want to point out. But I think that's an interesting point to note too. It comes back to the original points I made around the quite often these court orders around hate speech play towards that popular consensus of what we know to be socially, if not personally, the correct thing to believe in and the correct thing to say.
Yes, and there's
Or
a sense in which we could be out of touch. So, good example, if you think about Eurovision, as an interesting barometer about what people have to think about global events. So you had these mass calls for the Israeli contestants to not be allowed to participate. That I think the Irish contestant was very upset with Israel, and when they opened up the votes to the public, the Israeli singer completely dominated. And I don't think it's because the Israeli singer had a fantastic song. I think it was a show of support. But the elite judges didn't. So I think you can often have a sense, and you see it in our elections at the moment, the ANC took a very, very strong anti-Israel line on the assumption this would be very good for their support in terms of voters. And it seems to have not paid off very well at all. The ANC have been abandoned in the Western Cape. They almost don't exist there, which is where they were kind of doing a lot of campaigning to try and get Muslim voters. And I think if you ask the average South African, what do you think about this? They say we're not very wild about terrorist groups, storming into villages, killing women and children, engaging in mass mutilation and torture. We don't really like that very much, and are probably quite skeptical of some of the stuff the South African government's doing at the International Court of Justice. But of course, there is an orthodoxy among the press. So to try and find any voices that are skeptical of Hamas or skeptical of what the South African government has done in South Africa, very few and far between. So, as I say, elites can read the room, but they're reading a very particular room, which is, their friends. I often think that the way that journalists decide to write a story is kind of sitting around a table at a bar with their mates, and they kind of go, "What do you guys think?" Peter Bruce was quite fond of saying this is how he wrote his article every week. So he would say, "I'm tapping the pulse of the people," but really he was, tapping the pulse of his drunk journo buddies. He has no idea what the people think.
Yeah, I don't know if you're quite so spot on with the general sentiment around the Israel Gaza issue. I think the splits go much further than that. It depends. I think you're also reading a very particular room there, and I would certainly say that just with my little experience at my local polling station, which was probably worse attended than any other polling station in the country, so not a very huge sample size at all, I would say that both groups supporting both of those nations were out in much larger numbers than anyone supporting any local political party, and the odds were split 2-1, one side to another. We'll leave those results for future consensus later. But I thought that was really, really interesting. As much as you would say that perhaps that's worked against the ANC, I think in some ways it's probably worked for them, given just how diverse this country really is around these issues and how hard it is to play judge and jury when it comes to sentiments and when it comes to moral issues. And I think that that's really why this is such an important and also such an emotive issue, because issues of hate speech, especially as they become more and more vague, and especially as issues of what harm and crime and hurt actually become, become so personal, but they're also very, very emotional issues. These are issues that attach to people's identities at the end of the day, not just towards material concerns, which is what most of the law, let's be frank, is about, right? So these things are going to be argued hard. The test cases are going to get a lot of airtime, and they are going to cause problems as much as they might be intended to sort of heal harms. There's almost the sense that codifying hurt, that determining who is right and who is wrong in a personal moral issue, doesn't actually solve things as much as it can solve cases where there is a definitive answer as to, where there's a victim and where there's a crime. Because in so many of these cases, the boundary between who is the victim and who is actually the criminal are what's really on jury there. I mean, even coming back to your test case here around the Boersong and the EFF, it's really not so much about the principle as to whether this is hate speech or not that gets these issues so under people's skins. It's rather that the court is determining who is the victim here, which group has the moral high ground, and that's a very hard judgment to accept.
Yeah, there's quite a lot to unpack there. I mean, there's a sense in which, for a brief period in South African history, we took the view that we're all equal before the law and we're a non-racial society. Non-racialism is coded into Section 1 of our Constitution. And we'll try and abandon this oppressor-oppressed narrative. And it seems that project has been put on serious pause for a long time. And as you say, there's a contestation for, who's the oppressor, who's the oppressed. Instead of looking at individual wrongs, we've done it in terms of group identity, and that's quite dangerous. With reference to your voting situation, I mean, that strikes me as a good example of vocal minorities playing an outsized role in how we think about things. So think about someone like Zaki Ahmed, right? So he's one of the 7 independent candidates. I imagine that he's got 1,000 people who would have come up to him and said, Zaki, we're going to vote for you. We love you. And he would have felt that in his immediate space that
Extrapolate
everyone's,
that. Win.
yeah, I'm in, right? And then you sort of look at the actual results, and he's got 0.05, right? So catastrophic failure. And so I think often what happens is that we have a reference bias for immediate information, especially loud information. So imagine at your voting station, there were 100 people waving Israeli flags or people waving the Palestinian flag. You go, oh my goodness, there's a groundswell of support for movement A or movement B. 100 people out of 60 million is nothing. It's an irrelevant thing. It just feels very strong. If you see people also who are very emotional, if you think about during Fees Must Fall, how emotional some of those students were, sobbing and crying and rending their shirts, and this is a huge injustice. We have to do something. It's a minority position. You're not seeing all the students who just want to get on with, writing their exams. And so vocal minorities are very good at capturing the imagination of elites who often feel a sense of empathy of, I don't want you to feel so sad. What can I do to make it better? As you say, a lot of those laws that talk about emotional harm and things like that are these kind of like mothering laws, where it's like, my child is screaming and upset, and what can I do to make it better? And instead of thinking of the social repercussions of that, you're only thinking about the small individuals. And of course, there are second order effects that can be very dangerous. As we've seen, Fees Must Fall movement has caused enormous damage to our institutions. That spread like a virus through our universities. This decolonization project is very dangerous. You end up robbing many generations of students of, the treasures of global knowledge. Something, by the way, that is in the Freedom Charter. The idea there was that, it's important that everyone, regardless of race, is able to get an education that's not decolonized, but globalized, that, you can learn from every tradition. And that project as well has been abandoned.
Well, that's a lot to chew on. I'm sure I've taken up quite enough of your time. So if there's anything you want to wrap up, anything you want to clarify, backtrack on or reinforce, now is the opportunity, as well as if people want to get hold of you, where they can find you.
Yes, well, thanks for having me on. There's 2 ways you can see what I do. The one is I've got a YouTube channel that's under Mark Oppenheimer, where you can see all the interviews that I do, all the cases that I do. And then if you're interested in the more philosophical side, then have a look at Brain in a Vat. We've done about 200 episodes. We recently interviewed the world's most influential philosopher, Peter Singer. It's a nice, thoughtful way of having discussions and trying to model disagreement in a way that's civil and productive.
Peter Singer, the most influential, you reckon?
Widely regarded. So he's regarded as that for having done two big things in ethics. The one is the animal rights movement, and the other one is around global charity and the most efficacious kinds of donations.
Very good. Anyway, that's just an aside, but thank you very much.
That's right, I'm wearing red. I did that very deliberately to try and capture your attention instead of my usual black. I did that because I've got quite an important and very exciting, for me at least, announcement, and that is that our new book, Rescuing Our Republic, which has been written in conjunction with my friends and colleagues at Discourse ZA, is now out and about in bookstores across South Africa and available online for anyone else that is curious about South Africa. And as I've said before, as a futurist and a trained analyst and economist, I do think that South Africa is one of the clearest bellwethers as to where the weird Western world is headed. And as such, there's something you can learn from us at the bottom of Africa. We're ahead of quite a few of the trends that you're just wrapping your heads around. Anyway, this book is based on some of our most popular and most revealing, interesting, and important conversations that we've had over the last couple of years at Discourse ZA, which is a YouTube channel you should absolutely subscribe to. It's also available as a podcast if you're interested in anything to do with politics, philosophy, and economics. But the conversations in this particular book are focused on, as the title says, rescuing our republic, or more specifically, what civil society and individuals should be thinking about and doing and starting if they are interested in investing in a future for South Africa that we actually want to be a part of. Anyway, I would love for you to read this book and to give it to someone either that you like or that you hate, because the purpose of this book is to kickstart conversations around big, interesting, ugly even, but important ideas that are worthy of debate. So if you're planning on being bored or understimulated at a family or friend event this festive season, this is the book you need to give you the conversation starters to start a debate or a fight with those who you love or love to hate most.